BWF Solicitors, we take pride in our client service. As a niche law practice, we are conscious of the demands of our clients. We always offer a friendly, listening ear and sympathetic attitude. We've worked with thousands of people all across the UK in all areas of personal legal services. We have received great feedback and reviews from our clients. We are located at Seven Sisters in Tottenham on the 4th floor of the Anna House, right on top of the Victoria Line train station for your utmost convenience. We have a friendly office and provide all of the refreshments necessary while you wait to see a lawyer. We are dedicated to our clients and have a successful record of serving our clients. Solicitors of England and Wales are of high quality and are bound by the highest professional standards. We are officers of the court and are bound by standards of integrity, competence and conduct as part of our responsibility to uphold rule of law. Our solicitors and lawyers care about your case and are committed to providing the best possible service to you in the most considerate and careful manner. We hold 2 Law Society quality marks. Law Society accreditation helps to demonstrate that we have attained the requisite standard in the area of law and have the requisite expertise. BWF Solicitors, we're here to help you with your legal services when you need us.
Victon Estates provides professional and reliable service to landlords, investors and tenants. Our mission is to ethically and honestly serve our clients. We won't make promises we cannot keep, rather. We present a clear picture of the reality we can offer. We are here to help you with long and short-term let, property management, cash buyers for quick sales, stock repossession and mortgage arrears. For all your property needs, look no further. Visit us at www.victonestates.co.uk or call us on 07448619711. Victon Estates, your property is our pride.
Hello, ladies and gentlemen. It's such a beautiful day in London, UK, and I believe wherever you are all over the world, you might be also having a lovely weather. Oh dear, I'm looking forward to today's program. Let me quickly acknowledge our sponsors, BWF Solicitors, your #1 immigration law firm in the UK, Victon Estates Limited, property management company. If you want to sell, buy your property, or you want your property rented or managed, look no further, contact Victon Estates. And lastly, Eagle Heights International School, your #1 maths and tuition, extra tuition center for children ranging from year 7 to 6th form. Wow. Today's topic. Oh my goodness. Right. Let me quickly introduce Lawyer Eunice. She is a partner at BWF Solicitors and also a solicitor as well at BWF Solicitors. And with her, we're going to discuss today's topic, home and occupational, your right after a relationship breakdown. So let me quickly introduce Lawyer Eunice. Hello, Lawyer Eunice.
Hello, Vicky. How are you?
Yes, I'm fine, thank you. I'm fine, thank you. Today's topic is very, very unique. Home and occupational rights, if I got it right. Knowing what you are entitled to when your relationship breaks down. Lawyer Eunice, before I ask you the reason why you want us to talk about this topic, is there any updates for us in the past week?
Yes, so I just want us to all be made aware of the fact that most people are still thinking that we don't have any permits in terms of our EUSS family permits. So I think as much as possible, it means that we have to make people aware that we can still invite our family members who are spouse, children, parents, grandparents, grandchildren under the EUSS which is the EU settlement scheme. So if you have family members abroad and you're an EU national and you still want to make those applications, please, there's no deadline to those applications. You can still make those applications for your family members to join you here in the UK. So please, if you are one of those who thinks that, oh, you can no longer bring your family members as an EU national, that is not true. You can still bring your family members under our Appendix EU of the immigration rules. And then, of course, as I was talking the last time about the fact that there are those in the UK who were supposed to apply to the EU settlement scheme, but for one reason or the other, they have not been able to make those applications, whether it was because they were not made aware, it could be because of domestic violence, it could be because they are children, it could be because of some medical condition, it could be the presumption that they already thought they had settled status and they don't need to apply under the EU settlement scheme. So for whatever reason, if people were not able to make the application before the 30th of June 2021, then they have the chance to explain to their Home Office those reasonable grounds where they were not able to make the application in time, and that they will now be making the application and they'll be able to produce whichever evidence shows that they've been living in the UK for a continuous period of 5 years, or if they have lived here for less than 5 years, then they can provide evidence that they've lived here for less than 5 years. Yes.
Okay. All right. Brilliant. Before I ask Lawyer Eunice, to tell us the reason why she chose this topic, let me quickly tell our viewers, please share this live broadcast, because I believe it's going to, help a lot of people. It's going to be very informative, and possibly if any friend, colleague, or a neighbor is going through this situation, you'll be able to direct the person to where to go. So share this program. If you want to call into the program live, you can call us on 0744 8619 The number again is 0744 8619 Lawyer Eunice, I think my director is saying there's a feedback from your end. If you can turn down your volume a little bit, please.
Okay.
Wonderful. Yeah. Whilst Lawyer Eunice is doing that, like I said, if you want to call in live to contribute to the program, because I always would love for you guys to contribute to the program, send in your questions and call in live, and I believe with that it makes the program more interesting. So I'll be waiting for your phone calls and all your messages on our Facebook pages, Heritage TV, and also BWF Solicitors Facebook page. And myself and Lawyer Eunice will be able to pick those questions, and Lawyer Eunice will delve into it. So Lawyer Eunice, back to you. I have this feeling, this topic is drifting towards the family law aspect, which you guys are also specialists in family law. So tell us the reason behind this topic.
Okay, so there isn't really any special reason, but I think that a lot of people may be able to, should I say, relate to this topic. And the last time someone called me and it was in relation to something like this, and I thought it would be good to treat this topic so that at least if there's somebody out there who feels that they are currently in this situation and they don't know what to do in regards to how they can get a place to live or be, of course, in a place where they can say that they are looking after their children and their children don't have to worry about where they're going to sleep and the rest of it, then maybe it might help somebody who is out there. So I decided, you know what, let's do this as a general topic. And it was good that that person also phoned me to just inquire about it. Yeah.
So it's not just that you are getting a lot of requests from clients in this, topic.
This particular area. No, not necessarily. I mean, when people also go through divorce, this is also something that you will say you would go through ancillary relief, and so it is very common for people who are going through divorce. But because this is specifically out of those who are not necessarily applying for divorce, it is not as common as those that are going through a divorce. Yeah.
Okay. Okay. All right. So, Laura Eunice, why is the right? I mean, what is the right to occupy a home?
So when we talk about our rights of occupation, our Family Law Act, which is the one that was made, or should I say, enforced by the government in 1996, was one that gave rights to not just married couples, but also to cohabitees to be able to say that they can apply to the court for that right to be able to occupy their family home. So if for one reason or the other, let's say that there's a couple, they have had some misunderstandings, it's led to some arguments. One person within the relationship is saying, do you know what, we can no longer live together. I want you out of the house. We can't both be living under the same roof. Then what do you do? Because of course, it is important that you have some sort of resolution in terms of where you can live, and the court has a fair understanding of what people go through when they are currently under a lot of pressure to do what the other party says. And a lot of the time, we as lawyers have to advise people to always seek settlement out of court, and we have to advise them to make sure that as much as they can, it is better to resolve it out of court than to waste cost and try and resolve it within the court system. And so when somebody approaches you and they are telling you this is what is happening, you first of all have to make them know that they have to try mediation, they have to try out of court settlements and try and do as much as they can to get to some agreement informally. But if all comes to naught, then you obviously have to let them know that this is what your rights are under the Family Law Act, and you can make such an application, and then the court will also consider what your interests are or what your rights are under the law, and then hopefully you should be able to stay within that household or stay within the family home without having any issues whatsoever with the other party. So it's good to let people understand that this is something that is also available to them if they have tried all possible means to come to some agreement, but they still haven't been able to reach any sort of informal agreement.
All right. Okay. So, Laura Eunice, how will a person who is married go about applying to the court if an agreement cannot be reached?
So usually, if they can't reach an agreement and you have to make an application to the court, there is a claim form that the person has to fill. So if, for instance, it is the wife who is saying that, you know what, I can no longer live with this man because of what he is doing, and it's become unbearable to, should I say, live within the same household. And so maybe they may have children, and the children are just looking at everything that's going on, and it's probably affecting them psychologically as well. And so it becomes important that the party who feels that they need a place to live especially when you have children. It becomes necessary that the children will have a place to put their heads. And so, if it's the wife, for instance, who is saying that there's nowhere else to go, but because of the fact that the relationship has become sour, she needs a place to live with the children, the court will obviously have to look at the claim form that has been put through, and most claim forms will come with a particulars of claim, which is like a statement saying what it is that the person is applying for, why they are applying for the right to occupy the property, what the circumstances were which led to them coming to a disagreement, and the rest of it. And so, if there is any written evidence to be provided, it is the particulars of claim that will really show what the court needs to be looking at when they are making their decision in terms of who occupies the home. And so, usually, once that has been served on the court, lodged at the court, one has to also remember that they have to serve this on the other party. So if it's the husband who has to be served, then that copy will be served on the husband as well. And of course, once he has acknowledged receipt of the claim that has been made against him, then the court will go ahead to give a case management hearing. So it is a step-by-step process. And once you have a case management hearing, of course, now the court can hear the views of both parties. And if there isn't any out of court settlements, or if there isn't any agreements that can be made out of court, you will see that the court would then go on to make sure that there are other hearings made available to the parties so that they will come to some sort of agreement. And these can be long, should I say, in getting to the end. So if you are thinking about something easy, unfortunately, it is not an easy option, just with other cases that go to court. So you can have a case going on for like a year and a half, 2 years. And if it's really, really bad, then it can go on for longer. Yes, so as much as possible, it means that you have to make sure that people are aware that if you can't come to an agreement out of court, then this is what you have to be willing to, should I say, pay, or this is what you have to be willing to go through or endure to be able to get to your expected end. So it's one of those things that you always have to make the client aware of. Yeah.
Okay. Laura Eunice, when I shared this topic that we'll be treating today on social media, I had a lot of, if I look at the ratio, about 99% of men sent me messages saying they are very bitter that in such situations, it's usually the wives or the women who are favored. Why is that? Even, he is the one paying the mortgage. He is the one who bought the property and is paying the mortgage. But in the end, the property is given to the woman and he still pays the mortgage. A lot of men are very bitter. Why is it the case? Because when you were, just explaining to me, one thing I picked up was, if the custody of the children is with the woman, if the wife is the one taking care of the children, the children being with her, then definitely they should have a roof over their head. That is what I picked up. But a lot of men are very bitter, saying that it looks like in most cases women are being favored and they are just left hanging in there and they have to be paying allowances. So many things. Can you please delve into it, at least to put these men's mind at rest? Why this is the case?
So I know that a lot of men will be, should I say, the other party who are on the receiving end, and it doesn't seem fair, if I can put it that way. So most people will see it as unfair for the women to be the ones who are occupying and they have to pay the bills. I think that the whole point of the act was to protect these women and the children. So the intention of Parliament was to make sure that the woman and the children don't go hungry, they don't have to suffer because of what the other spouse may have done to them. It could be that in this modern day age, the woman is the one working and the man is the one with the children. And of course, if that's the case, and the courts say because the man is the one who looks after the children, he should occupy the house, I don't think any man will be angry about that, because they're thinking, well, he's the one with the responsibility of the day-to-day care of the children. So why shouldn't he have the right to occupy? It's just because the tables are turned, and so it seems unfair to the man. But in most situations, if the woman is not working and you are saying that the woman has to stay at home, she has to look after the children, she has to look after the affairs of the house, run the house, make sure the house is clean and tidy, and do the rest of it, and also make sure that you are also well fed and well catered for. She's doing all of that for the benefit of everybody living within the household, and it's not just herself. And so it may seem unfair, but the court is looking at the fact that this woman does not have the financial capacity to be able to look after the children if you were to throw her out of the house. So if the court or the law did not offer that protection to the woman, then it meant that, well, any man who decided to chuck his wife out of the house could just chuck his wife out of the house, and then the wife and the children will have nowhere to go. And if for one reason or the other, the money that people will say you take from benefits is not enough, and they have to go and be offered temporary accommodation at a bed and breakfast, can you imagine what these children will be going through? Because they are now on benefits, they don't even have proper accommodation. They have to sleep in a bed and
also
breakfast.
Be a burden on the government, isn't it?
On the state, yes, on the state. And so the intention of Parliament is to make sure that these women and these children are protected. So it might seem unfair, but in the greater sense, it is not unfair. It is, shall I say, a fair process if you look at it in the wider picture. So I feel that, unfortunately, it may seem like the man has to pay or has to do the bulk of the financial duties, but it is only because he has the capacity to pay. If the woman had the capacity to pay, then of course, if she had a part-time job and she could pay part of, let's say, the mortgage, then why not? But usually it is the case that maybe the work that she's doing is not enough to meet that expense of the mortgage. Maybe it is just enough to look after the maintenance of the children. So they shouldn't feel that it is an injustice to them. It is.
So
it is
it's got nothing to do with who is at fault, isn't it?
No, it's more to do with who is able to, should I say, make such payments. So it's not necessarily about who did what, and most people will see that adversarial view that, well, this person's at fault and this person's at fault, and I don't think that the court is looking at who did what and who did that. Is looking at the capacity of both parties to be able to reach an agreement or a settlement. Yeah.
So Lawyer Eunice, if a person is not married to his or her partner, what right does he or she have to occupy the home?
So in a case where, for instance, let's say that both parties are not married, so they're just cohabitees and they've been living together for, let's say, the past 8 years, and they are currently not getting along. So they don't have anything to do with each other anymore, and they just believe that the relationship is over, as they would say. In that case, usually it helps if the other party was also somebody who contributed to the purchase of the property. So either that they bought the property together, or they make contributions towards the mortgage. So usually when you have both put money together to pay for the deposit, that would mean that you own the property as joint tenants. So that means that your names are on the title deeds of the property. If not, and you are making contributions to the mortgage, so it might be that one person's name is on the property, but then you, as the other cohabitee, have been making some contributions towards the mortgage every month, or let's say every 2 months, or whatever the case is. Then of course that would mean that you have some beneficial interest in the property, because you are making some contributions towards the mortgage of the property. And that's what the courts will usually call a resulting trust, that there has been some sort of agreement for you to be able to say that the both of you own the home, even if it's in that person's sole name. And when you look at our Trust of Land and Appointment of Trustees Act 1996, which is in short TOLATA, you have the fact that a cohabitee may not necessarily have the trust of land, or may not be one of the parties who is on the deed as an owner, but they may have a beneficial interest, which is that they may have agreed that maybe from time to time they make mortgage payments, and so if anything, maybe the other party should have 45% of the shares of the property, or the other party should have 30%. So if they had some sort of agreement, usually that will come through within the conveyancing documents and things like that. Most of the time, it may be that they didn't have anything like that on the conveyancing documents, and it's something that was said. And so the bank statements will be the only evidence that will show that they have been making contributions towards the mortgage, and that they believe that they have a beneficial interest in the property. And at least if they are able to show this, of course, the court will allow them to make that claim in terms of them having that beneficial interest. And then under TOLATA Section 14, they can therefore make a declaration as to who should occupy the house. The court can make a declaration as to who should stay in the household, and how much they should contribute. So if it's the case that the party who wants to stay in the house can pay for the mortgage and also sustain the home, then of course they can go ahead and make a declaration for them to occupy the house and continue to pay the mortgage. And so there are factors that the court will go ahead to look at when making such decisions. And even though our Family Law Act may not necessarily protect those that are not married, at least we have some protection offered by the Trust of Land and Appointment of Trustees Act. So that helps with those who may not necessarily be married. And then you have people who may be engaged. So, in our African culture, when you have the customary marriage done, some people call it engagement. And if there has been some sort of engagement in that sense, and the engagement has been terminated, but they both live together, they both may have children together, and the engagement was terminated for one reason or the other, you would have our women's right of women to the property. So they will be able to make some sort of claim in in terms of whether they can own the property. And so it's important that they can show that they had some sort of interest. And if there was a beneficial interest in the property, then they will go ahead to apply to the court to say that, yes, we were engaged for this period of time. However, we are no longer engaged, and therefore I want to apply to the court for the court to also give me some right to occupy this home, as it were, so that my children will also have a place to live for the time being. And so it helps when at least you are aware that this is what I can be offered in the meantime, whilst other things are being sorted out. Yeah.
Let me just send a question saying, if both partners, like you said, are not married, but the man is paying the mortgage while the woman takes care of the other bills, meaning there will not be any evidence showing that she contributed to paying the mortgage. But then again, they came to an agreement she will be taking care of all the other bills while the partner pays the mortgage. Would she have any right?
If they're not married, then unfortunately it becomes very difficult for the courts to actually ascertain whether there was any sort of contributions whatsoever. So if it's not financial and there isn't any agreement, it can be oral, it can also take the form of express agreement. But if there isn't anything like that, and unfortunately they are not married, it makes it very difficult for the court to then ascertain whether this other party was a party to this whole intention of you owning the home. So, for instance, if you are saying that you are both not married, you've just lived together for a long period of time, you both want to occupy the home, and unfortunately, the other spouse, or should I say, the other party, is not able to show that the whole intention between you two getting the house was so that you could both own it together. So there is nothing within the title deeds, and then there's no financial contribution in terms of mortgage payments and the rest. Then, of course, it means that you will need to make an application, or the woman will need to make an application to the court to say that, well, there isn't any evidence to show that there has been any beneficial interest in the land whatsoever. It might help that the woman will make an application under Section 34 of our Family Law Act, which is an occupation order to let her stay in the house. And usually that doesn't last very long. Usually when the court makes an order for occupation, it's in relation to non-molestation orders as well. So most people would make an application for non-molestation and occupation order. So it means that the party is saying that this other person has been pestering them, harassed them, has been abusive towards them. They can no longer live with them, and therefore they want them to leave the household, whereas they can occupy the household. And usually it's for a period of 12 months. And that means that after that period of 12 months, that person can return to the family home. So in those cases, it makes it a bit difficult where, for instance, there are no agreements whatsoever, and there's no evidence to show any financial contributions whatsoever. So it becomes necessary that, of course, they can make an application for occupation order instead, rather than having the right to occupy the household.
Okay. Let me remind ladies and gentlemen, if you've just joined us, this is the Legal Hour Show with BWF Solicitors. And today's topic is home and occupation rights, knowing what you are entitled to when you are in a relationship breakdown. We would like to hear from you. Send in your questions on all our social media platforms, on BWF Solicitors Facebook page, and also on Heritage TV Facebook page. We'll be able to pick up your questions, and Lawyer Eunice will be able to answer those questions. You can also call us live on 0744 8611 711. If you want to remain anonymous, I'm happy to pick up your call and not mention your name. And Lawyer Eunice will definitely answer your questions as well. Lawyer Eunice, are you there? Yeah.
Yeah.
Lawyer Eunice, I've got Femi who is saying, what does the court look at when determining property disputes?
So usually when a case is before the court has certain duties under the Family Law Act and also under Tolata to be able to make certain decisions. And one of the things that the court will look at is the intention of both parties. So whether you are a married couple or you are a cohabitee, the court has to look at what your intentions were when you were getting the property. So was it that you both decided that if you get the property, you will both have same rights to the property? And so did you both decide that once you bought the property will be in both your names? Or even if it was not in both names, you had the intention that you will both own the property. And so if, for instance, the man is the one who is going out there to work and to do the rest of it, the woman is going to stop her job, look after the children, and look after the home. And therefore, in that sense, the home belongs to both of you rather than just the man. And so, of course, if that is the case, usually, if it's not, like I was saying before, if it's not in conveyancing documents that there was that intention, they will look at whether there were some form of express agreements from things you've written down, and during the time you bought the property, maybe you spoke with your mortgage advisor, you let them know that because you'll be getting a mortgage, the both of you would want to be able to get the best mortgage for the both of you. It could be things that, for instance, you had told your solicitor, and so you obviously expressed that because you both want to be able to buy this property. One person may have to stop working to be able to look after the house and the children, and therefore that is where your intentions were lying at the time. It could be relatives, it could be friends, people that you may speak to who know that this is what was agreed between the two of you before you decided to make the next move of maybe leaving your employment to be able to care for the children and take care of the home. So obviously these are evidences of what your intentions could have been at the time that the property was being purchased. And then as time goes on, of course, you will have people who would also make contributions. And like I was saying before, bank statements don't lie. So if you were making financial contributions towards the household in terms of the mortgage payments, that could also be considered as well. If the court is to look at the purpose for which you decided to do those things, of course, it seems subjective, but there are different case laws that obviously show what the court is looking for. So it's not just you saying that you were making contributions towards the home in terms of buying the food and making sure that the house was well kept. They need to see proper intention. And so sometimes it may be that you've looked after the children for the past, let's say, 15 years, and you had a good job. It wasn't as if you didn't have a good job to work in, and that is why you were at home taking care of the children. So you had a good job, you decided to leave your job for the purposes of the home. And so you decided to stay at home, look after the children, do what you had to do as a wife, and to take care of your husband and your children. And therefore, the court likes to see that there was that intention and there was that purpose to you coming to that agreement in the first place. And you have other case laws that show that it has to be a substantial contribution to the household. So if it's not financial payments to the mortgage, then it has to be contributions in terms of making sacrifices like leaving your job. It has to be that long-term sacrifice of looking after the children, making sure that the home is well kept and the rest of it. And then, of course, if you are the one who is also paying for decorations, for instance, to the household, and it's not just, should I say, buying flower vases. I'm talking about the kitchen getting redone or the bathroom getting redone. Those kind of things can also be considered. So it shouldn't just be mere sort of contributions in terms of shopping and buying things for the house, but substantial contributions towards the household. And then it will also consider the fact that there are children. And so if there are children, they would consider the fact that these children definitely need a place to lay their heads. And if they are young, and we all know that it's a struggle to look after children sometimes in this country with all the things that go with it. And so if the children are very young, for instance, and you need a place to make sure that they know that this is home and they've come home and they can be at peace whilst at home, then of course the court is going to consider this as well. And the best interest of the children is one that the court considers to be very important. And so that is another area that the court will also consider when making their decision. And of course, if there is a mortgage to be paid, the court is also going to consider who the creditor is, and the creditor is usually the bank. And so, yes, if the bank has to get its money, they're going to consider who is able to pay that money. And so, of course, if mortgage payments have to be paid, the court has to consider who best to make those repayments in terms of the household. And so the court is going to be looking at all these different factors and the capacity of the parties to be able to pay for the mortgage as well, if it comes to that. Because at the end of the day, there will be no home if the mortgage is not paid. And so that has to be considered as well. And if the court sees it fit that they need to sell the house, it can go ahead and also make an order for the house to be sold, and for each party to be given a share of the sale proceeds. And then if it's best that the other party, both parties rent, then of course they can go ahead and rent. And if the other party feels it's best to use that proceeds for a down payment to another house to get a smaller place so that they can make small or less mortgage payments, then they can go ahead to do that as well. So these are some of the factors that the court will look at when making such a decision in terms of whether a wife or a husband or a cohabitee should remain in the home. Yeah.
This reminds me of a very funny story I was told just yesterday, that a couple were in this situation, but in the end, they were allowed to stay in the same house, but it's like they asked them to share the house, if I should put it that way. So everyone goes out, comes in, you like, if you don't want to say hi to your ex-partner, it's your own choice. You can have a boyfriend out there, come in with a boyfriend. He also has his girlfriend, come in with his girlfriend in the same house. I mean, how does that happen? Does the court allow that to happen? And why should they
So of
be
course,
living in the same house?
so
Because one
like
day
I was
one will
saying,
get it and the other will be strangling the other one.
that that usually happens a lot with occupation orders. So
Right.
where, for instance, um, the parties are not married or they're renting a property, and of course, if for one reason or the other, the evidence that you've put forward to the court doesn't seem as if the other party is a violent person, or should I say, such an abusive person that you cannot live with them. And so they would say to you, this is the home, you can live on different parts of the home. So maybe the living room that you have is somewhere at the other end of the household rather than on in the middle of the household, for instance.
Okay.
And so maybe the living room, because it's on the other end of the house, that space belongs to one party, whereas the rest of the house can belong to the other party. Or for some people, there's an extension, and so of course, if you have the conservatory or whatever, um, as part of the household, then of course that side of the house should be for one party, and then the other party occupies the other side of the home. And so, if that is the case, then of course you can both share the household in a way. That doesn't mean that you're not separated. It just means that the other person needs a place to lay his head. And if it is the case that they are not financially capable of getting a place to rent because it's going to be expensive, for instance, and their income is not such that they can have a place to rent on their own.
Oh, do
Mr.
we have
Oliver,
Oliver
come and
with
say
us?
hello.
Hello, Oliver.
So if
Hi,
it is such
Oliver.
that
How are you? This is another aspiring solicitor. Watch out for him.
So if it's such that you cannot place a place to rent, and the court
Yeah.
feels that it is necessary that you share the household, then it means
Yeah.
that you have to be able to live with this person because they are not capable of maybe getting another place to rent or to go and live in. And that is why the court has made the decision for them to share the household with you. And so it does get to that. And I feel that, like with most people, when we are talking about this, it seems almost unreal, but it does happen. And as I was
That's
saying, the factors that the court has to consider are looking at also the capacity of both parties. And so if it means that you getting an occupation order, the other person cannot get a
Oh,
place to live, then they will have to make that decision to share the
oh.
household.
Let me quickly, if my producer is still there, I think we have to take a little commercial break for Oliver to settle. Then we will definitely come back. Yes, let's take a little commercial break.
Thank you. Thank you. Thank you. Thank you.
Right. I think my producer is still trying to put things together. Right. Laura Eunice, what I wanted to also ask is, regarding this issue of the both um, parties in the same property,
Yeah.
at what point will they decide, okay, let's sell the property? Because I was thinking, why don't they sell the property and each party takes their share to, invest in another property instead of
Well,
paying
if
the. Was that not an option?
so, if it is the best option in the circumstances of that couple's circumstances, then of course the court can make a decision for the property to be sold. But it is the case that most of the time it might be that the children are very young. It might be that the woman is not working, so there's no way she'll be able to get a place to rent because she's obviously not working. And so the best thing might be that the mortgage payments are done by the husband, and then the children have a place to stay. So most of the time it is the circumstances in which the couple are in that would determine the court's assessment. And so, of course, when I was talking, I was making a mention of the fact that the court will have to consider obviously the purpose and the intention of the parties, as well as their capacity to be able to make those financial contributions to the household, and also look at the fact that there are minors involved. And so if the children are young and the woman is not working, for instance, it would not make sense to sell the property and say, do you know what, you both have your shares, because the children need a place to stay now, and they have to be able to be catered for without having that disruption to their lives, as I may put it. And so it helps that they remain in the property, that whoever needs to make the mortgage repayments makes those repayments until such time when the children are old enough, or when maybe the woman starts working and she's able to make the mortgage repayments.
Oh, all right. Great, brilliant. Whilst I wait for my producer to give us a little break, I've got okay, this person wants to stay anonymous. So it says, I'm asking this question in relation to a friend's issue. I have a friend who has been having issues with her husband for some years now, and things have gotten worse. They have 3 children who are all under the age of 10. She's contemplating divorce but hasn't done anything about it. I wanted to find out if she can apply to stay in the house with the children whilst the man lives elsewhere.
Okay, so this person who is asking the question for the friend.
Okay, Eunice, before you answer this question, 1 second. I think my producer is ready. Let's take a commercial break, ladies and gentlemen. A quick one. Stay tuned. We'll be right back.
BWF Solicitors, we take pride in our client service. As a niche law practice, we are conscious of the demands of our clients. We always offer a friendly, listening ear and sympathetic attitude. We've worked with thousands of people all across the UK in all areas of personal legal services. We have received great feedback and reviews from our clients. We are located at 7 Sisters in Tottenham on the 4th floor of the Anna House, right on top of the Victoria Line train station for your utmost convenience. We have a friendly office and provide all of the refreshments necessary while you wait to see a lawyer. We are dedicated to our clients and have a successful record of serving our clients. Solicitors of England and Wales are of high quality and are bound by the highest professional standards. We are officers of the court and are bound by standards of integrity, competence and conduct as part of our responsibility to uphold rule of law. Our solicitors and lawyers care about your case and are committed to providing the best possible service to you in the most considerate and careful manner. We hold 2 Law Society quality marks. Law Society accreditation helps to demonstrate that we have attained the requisite standard in the area of law and have the requisite expertise. BWF Solicitors, we're here to help you with your legal services when you need us.
Victon Estates provides professional and reliable service to landlords, investors and tenants. Our mission is to ethically and honestly serve our clients. We won't make promises we cannot keep, rather. We present a clear picture of the reality we can offer. We are here to help you with long and short-term let, property management, cash buyers for quick sales, stock repossession, and mortgage arrears. For all your property needs, look no further. Visit us at www.victonestates.co.uk or call us on 07448619711. Victon Estates, your property is our pride.
Welcome back. Thank you so much for staying with us. And if you've just joined us, this is Heritage TV, the Legal Hour with BWF Solicitors. And today's topic is home and occupation rights, knowing what you're entitled to when your relationship breaks down. And we are live on all social media handles. You can also catch us on BWF Solicitors Facebook page. They are live there, and we are also live on Heritage TV, Facebook page, YouTube, all social media handles. You can contribute to the program by sending in your messages. If you want to call us live on the program, our number is 0744-8619-711. The number again is 0744-8619-711. I've got people who are asking, to have Lawyer Eunice's contact details. Please be patient. You will definitely have it at the end of the show. Back to Lawyer Eunice. Yes, Lawyer Eunice, would you like me to go through the question again, or
Yes, please.
Okay, wonderful. Right. I hope Oliver is all right now.
Yes, he's fine with his dad. I think his dad lost him.
Right. Yes, the question is, the person says he's asking this question in relation to a friend's issue. I have a friend who has been having issues with her husband for some years now, and things have gotten worse. They have 3 children who are all under the age of 10. She is contemplating divorce but has not done anything about it. I wanted to find out if she can apply to stay in the house with the children whilst the man leaves elsewhere.
So, this is a genuine question which happens in most people's cases where there are marital disputes. And so, in a case like this where the woman is looking after the children, we don't really know much about what the circumstances in regards to the property is. But if it were the case that the woman and the man own this property and they are looking to have at least one person remain in the property, and I think in the woman's case, of course, she's looking to remain in the property with the children. So if it is a house that is owned by either the husband or both the husband and the wife, then of course she'll be looking to apply to the court under Section 30 of our Family Law Act for her to have the right to occupy the home. Because of course, if she can show that she has some beneficial interest, even if she's not on the title deeds, the court may allow her to remain in the home, and then the children, of course, will continue to remain in the home until such time as, of course, if the children grow up or when it is possible that the woman may take up a job or may start having some sort of income which will help to pay for the mortgage payment. If they both are married and for one reason or the other, they may not necessarily own the home, and so as it were, they are both renting the home, the court can still make an order for the woman to continue to remain within the household and for the other party who is working to make the rent payments as much as possible. And
Okay.
so it helps that the woman is able to show that she has is married to this person first of all, and that there is some sort of beneficial interest because they both intended that they would live within this household. In the case where, for instance, we are saying that it's rented property, then of course, when an occupation order is sought, as I was saying before, those don't last very long. It's just for a year, and you don't want to have this person always in your face. So
And
it helps that if you can rent elsewhere, that of course you can rent somewhere else after this person has been given that occupation order. And with most occupation order, if the person is seen to be violent or abusive or in any way going to harm you or the children, then of course they will make sure that he will not continue to remain in the household or share with you in the household. And so obviously he'll be restricted from even coming near the property in any case. So of course, if that is the case in her situation or his friend's situation, then of course he can seek further legal advice, because I'm not sure what the circumstances are in relation to the home in which they are living in. Yeah.
brilliant, brilliant. Right. Um, I think my last question is from Ahmed. Says, would it be the same right for someone who is renting a property?
So, as I was explaining with this one, so if, for instance, they're a married couple and they own the property, of course, they have the right to apply to the court to occupy the household. But then, if it's somebody who is renting the property,
Hmm.
we all know that if you're renting, there's always a contract or there's always some sort of tenancy agreement, and you may not necessarily have the right to occupy the property for as long as you would like. And landlords always have the upper hand when it comes to the law. So if they want to evict you at some point, they may be able to find a reason to evict you. And that's why most people would go for an occupation order. And if an occupation order is sought and the court gives you that period of 12 months, it's saying that you are restricted from coming near the household or coming near any member of the household, then of course you have that 12-month period. After that, the person is free to come and live in the household because he's no longer or she's no longer restricted to that order. And so it makes sense that, of course, once you've made an application to the court that you want to be able to remain in this house or in the property, even though it's rented, maybe you are not working, maybe you are looking after the children, you want the other party to be able to make the rent payments whereas you remain in the property, then the court will also look at that as well. And then if it makes sense that maybe you find another place to rent, or you find out if you are able to get some sort of housing benefit to be able to cover the rent, then make sure that you do seek some advice as to how you can make those rent payments, so that you can also speak to the landlord in terms of changing the contract or the terms to be in your name rather than the other party's name. Yeah.
Okay. All right. Okay. Have you got any questions coming from your end on the BWF platform? If not,
Platform,
then I think we
not
will have to. Okay. Right. Okay. So in that case, I think you just briefly summarize and give us your details for those who would like to contact you.
Okay. And so, as I was saying, of course, there might be people in this situation, and um, nobody likes it when they are having a tough time in their home. Your home is
Mm.
supposed to be peaceful, it's supposed to be a place that you can go and unwind, especially when you have a tasking job that you do during the daytime and the rest of it. And so when it comes to home disputes, it's very um, one of those ugly situations that you don't want to find yourself in, basically. And so I believe that if anybody who has heard what I've said today and feels that they want to contact me outside of the program, because I really feel that this is a sensitive issue and most people may not necessarily come and speak on the program to say A, B, or C. And I
Yeah.
remember during the week when I tackled it, um, people contacted me outside of the program to just want to find out more and what they can do. And so if you
Yeah.
think that you are in this situation and you want to know how best to come to some resolution, then of course I will not hesitate for you to contact me. My contact number is 075 35 81 3910. So 075 35 81 3910. And as Vicky said, I am a solicitor at BWF Solicitors, and our offices are situated in London. The address to our office is the fourth floor of Anna House. So, fourth floor of Anna House, 214 to 218 Tottenham High Road. So, it's 214 to 218 Tottenham High Road, London. And the postcode is N154NP. So, N154NP. And we are opened from Monday to Friday from 9:30 a.m. to 6 p.m. Our office contact number during office hours is 0208 493 7340. So 0208 493 7340.
Right, Eunice, we very much appreciate you. We thank you so much taking time off your busy schedule. You know, like Oliver needed you, but you had to get your husband to take care of them whilst you spend time with us to educate us and also show us, one of few things that when anybody is in this situation, the necessary steps to take. So we don't take it for granted. We thank you so, 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 so much. And we also want to thank your team as well, especially Mr. Bernard Owusu. We thank you so much for the support for this platform. Very much appreciated. Um, Ladies and gentlemen, we'll definitely come back again, same time next week. But before we leave, I will have to say show appreciation and say a big thank you to our sponsors, BWF Solicitors. Even though Lawyer Eunice has given their address and contact details, I would also like to say that they are also experts in civil litigation, family law, and also immigration issues. So if you have any queries or concerns, do not hesitate, contact them. And the number is 0208 493 7340. That's the office number, 0208 493 7340. And of course, our other sponsor, Eagle Heights International School, is a maths and English extra tuition center. If you want your children to get occupied this summer holiday, the team are there to support your children with their maths and English tuition support. Contact them on 075-437-07121. The number again is 075-437-07121. I think at the moment they are having this promotion free assessment. So please do get in touch. And also lastly, Victon Estates Limited. Anything about properties, get in touch with them. The team will be there to help you. Heritage TV is a media house, and I know since we are in summer and the restrictions are being relaxed from the 19th of July, people would like to be holding functions, wedding, what have you. Heritage TV are available, have very reasonable packages for them to cover your events live, and it will also be shown on our Heritage TV live platform. So do not hesitate, get in touch with the team, send them a message. They are live, they are on all social media handles. Just send us a message and they'll be able to speak to you through their packages. And I believe that having them to cover your programs will make your program very special. So get in touch with Heritage TV for all your media requests. On that note, Lawyer Eunice, let's together say bye-bye to all our viewers. And we will see you again next week, same time at 12 noon. Bye-bye.
BWF Solicitors, we take pride in our client service. As a niche law practice, we are conscious of the demands of our clients. We always offer a friendly, listening ear and sympathetic attitude. We've worked with thousands of people all across the UK in all areas of personal legal services. We have received great feedback and reviews from our clients. We are located at Seven Sisters in Tottenham on the 4th floor of the Anna House, right on top of the Victoria Line train station for your utmost convenience. We have a friendly office and provide all of the refreshments necessary while you wait to see a lawyer. We are dedicated to our clients and have a successful record of serving our clients. Solicitors of England and Wales are of high quality and are bound by the highest professional standards. We are officers of the court and are bound by standards of integrity, competence and conduct as part of our responsibility to uphold rule of law. Our solicitors and lawyers care about your case and are committed to providing the best possible service to you in the most considerate and careful manner. We hold 2 Law Society quality marks. Law Society accreditation helps to demonstrate that we have attained the requisite standard in the area of law and have the requisite expertise. BWF Solicitors, we're here to help you with your legal services when you need us.
Victon Estates provides professional and reliable service to landlords, investors and tenants. Our mission is to ethically and honestly serve our clients. We won't make promises we cannot keep, rather. We present a clear picture of the reality we can offer. We are here to help you with long and short-term let, property management, cash buyers for quick sales, stock repossession and mortgage arrears. For all your property needs, look no further. Visit us at www.victonestates.co.uk or call us on 07448619711. Victon Estates, your property is our pride.